And almost.
Woo, we're here.
Not yet. There, we got
There
it.
we are. Sorry.
You stay up if you don't.
Can you get rid of that? All right, there we go. Good. All right. Good morning. This is Senate Health and Welfare. We are now in our committee room in the State House, and it's really great to be back and see everybody in person. And we look forward to working with folks going forward. It's March 8th. And this morning, we're looking at a couple of bills that we've been working on, and hopefully we can act on them within the week. We have 3 bills we're looking at. And the first bill is S-72, an act relating to the Interstate Compact on the Placement of Children. Michelle Childs and Tracy Casanova are here to help us understand what's different about this in this bill as compared to current statute. So thank you for being here, Michelle and Tracy, appreciate it. I will let you just go ahead with the testimony and go through the bill with us, please. And just as a side note to folks who are watching, our goal is to allow for witnesses to stay remote. Makes a lot of sense. Our room is small and has a very small capacity. So just stay in touch about Zoom information as we go forward. Okay, Michelle.
All right, good morning. Nice to be with y'all this morning. So I'm gonna do the walkthrough. As you know, it's a little dry. It's a little long, and it's heavy on kind of procedural stuff. So I've gone through the draft and just highlighted some issues that I want to draw your attention to. So if I skip over something, because to me it didn't seem critical, you know, and you want to go back, please let me know. And I'll try to answer questions as best I can, but I'm so grateful that Tristy is here because as you know, we have a version of the compact now. We've had it for decades, and therefore I haven't ever worked with it before. As you know, compacts cannot differ. The whole idea of a compact is for all the states that are members of the compact to adopt the same exact language, so there's consistency between the states with regard to their operating procedures. And the underlying reason for having this compact is so that if a child who is in Vermont is then placed in another state, that there's consistency, and that child is going to receive the same care and services and things like that in the receiving state as they would in the sending state. So we're talking, you know, as if in Vermont. So I'm going to start out. Aaron, can you let me share my screen, or you might have already done that?
I did.
Oh, you did? Great. Thank you. Can everyone see that? All right.
You know, it would be, yep, if you would magnify it just a little tiny bit more.
Oh, sure.
That's good. That's good. Thank you.
Sure. So the first section is just obviously that when this would take effect, it would repeal the old one, so it'd be replacing it. We're working in Title 33, so in your Human Services title. I'm going to start out and go through kind of the purpose, because I think it helps kind of orient you about, you know, why there's this legislation. So you'll see at the top of page 2, the purpose of the compact is to provide a process through which children who are subject to the compact are placed in safe and suitable homes in a timely manner. It's to facilitate ongoing supervision of a placement and the delivery of services and communication between the compact states. It's to provide operating procedures. It's to provide for the promulgation of rules and the enforcement of those rules that are within the compact. And it's to provide uniform data collection and information sharing between the compact states. It's to promote coordination between the compact and other compacts, like the Interstate Compact for Juveniles and the Interstate Compact on Adoption and Medical Assistance. Number 7 is to provide for the state's continuing legal jurisdiction and responsibility for placement and care of a child that it would have had if the placement were within that state. And then finally, at the top of page 3, it's to provide for the promulgation of guidelines in collaboration with the Indian tribes for interstate cases involving Indian children. So the next section is definitions, and I'm just going to go through and hit a few highlights on the definitions. The first one, I'm sorry?
Michelle, yeah, why don't we stop and allow for questions after each section?
Okay.
Yeah, it's up to Michelle. Do you think that will work?
Sure, no problem. Plus my camera just fell, so.
Okay, go ahead.
I just wonder if the term Indian children, is that what's required in all the drafts, and is that the
That
term
is the
using?
language. The language is what it is. So
Okay.
you don't really have a choice on the language. Sorry if with my whole crazy camera
You
setup
fall
here.
down?
No, I didn't fall down, but my camera did.
No.
Hold on a second.
Can I ask, maybe, is there a reason for the Indian children? Is that related to federal? Is there something in federal law that provides for that? I'm trying to remember if that's the case.
I don't know how this works. I mean, maybe
Okay.
Tracy does, but like with the Indian Welfare Act or things like
Yeah.
or other federal laws, I'm not sure.
Yeah,
Okay.
it probably is. It says as permitted by federal law.
Yeah, so that may be that.
I figured that was the answer to the question. I just wanted to check.
Right, right. So, this is the kind of tricky part with compacts, which is that, we look at them and there's all kinds of little places that we'd like to tweak, maybe even just like you had mentioned, just on language. It might not even be substantive, but the language is to be identical among the compact states. So looking at the definition sections, so 5902. So the first one I want to draw your attention to is approved placement, which is the public child placing agency. And you'll notice we're going through this. There's different rules for public child placing agency and private agency. So I'll try to be very clear about that when we're talking about these. So approved placement means the public child placing agency in the receiving state has determined that the placement is both safe and suitable for the child. The next one is assessment. And so that is an evaluation of a prospective placement by a public child placing agency in the receiving state. So if Vermont was going to be placing a child in New Hampshire, it would be New Hampshire doing the assessment. And they would be doing the assessment to determine if the placement meets the individualized needs of the child, including, making sure that they are safe, they have stability, that their health and well-being is taken care of. And that assessment is only applicable to placement by a public child placing agency, so not for private entities. And we'll get down to the home study, which is applicable to the private ones in a moment. I think the next definition, is the top of page 4, Subdivision 6 for home study. That's an evaluation of a home environment conducted in accordance with the applicable requirements of the state in which the home is located. So if it's going to be, if the child is going to New Hampshire, then there would be a home study and in New Hampshire, and it would be done in New Hampshire, sorry. So let's see. Indian tribe, there's a definition of Indian tribe. So I think we're probably using these standard terms. There's a definition for that.
Yes, federal.
Yep. So line 16, subdivision 10, legal risk placement or legal risk adoption. That's a placement made as like a preliminary step to an adoption where the prospective adoptive parents acknowledge in writing that a child could be possibly ordered returned to the sending state or the birth mother's state of residence if it's different from the sending state. And so I think you guys are probably familiar with that concept. The next
Can I ask a question here?
Sorry? Sure.
So you talked about an adoptive child.
Mm-hmm.
So are we also talking about sort of fostering of children that are out of state? And so is there a distinction being made between those two placement types?
I think it is applying to foster kids as well.
Okay,
Mm-hmm.
thank you.
Sure.
So can I just ask a question about
Sure.
the rules for adopting, the adoptive children? Are they the same? They're not the same in every state? Like you're saying that they could be returned to the birth mother?
Well, if you had like a legal risk placement, and Trissy, please correct me if I'm wrong here, which is that, so if there was going to be, let's say, a child was in DCF custody, there was maybe going to be a termination of parental rights. Their child is in DCF custody. They're looking at placing perhaps with kin in New Hampshire, and it may be that, you know, that adoption, like it may be like the steps are being made towards adoption, and that kin is going to be adopting that child, but there's, you know, until there is the official kind of termination of parental rights and the adoption and things like that, you know, that those prospective parents are at legal risk, right? So that everything may not follow through, essentially. And so it's kind of like, you know, in the adoption world, you know, birth mother may, you know, if you're talking about a private adoption, may change her mind, you know, things like that. So does that answer your question?
Yeah, until the adoption is finalized.
Right. Yep.
Thank you.
Next one I think is important to look at is Subdivision 14 on line 10 of page 5, which is Notice of Residential Placement. And that means information regarding placement into a residential facility provided to the receiving state. So when a public agency is going to place a child in a residential facility in another state, they have to notify that other state. And we'll get to it a little later, but one of the things that is a change is right now, this act applies to parents who place their kids in residential facilities in another state, but it wouldn't under this new compact. But this is talking about when one state is placing a child in another state in a residential facility, they have to notify that state. Subdivision 16 is the definition of private child placing agency. So that's any private corporation, agency, foundation, institution, charitable organization, attorney, et cetera, that is involved in placement of a child from one state to another. Subdivision 6 on line 17, Subdivision 17 is provisional placement, is a determination made by a public child placement agency in the receiving state that the proposed placement is safe and suitable for the child. Subdivision 18 is the definition of public child placement agency, which I think we get that. Subdivision 21.
Michelle, is there
Yes.
is there a requirement in the compact that there be one point of contact in a one designated agency?
There are things later on in the draft that talk about, like, you have to have kind of an office or an instrumentality within the state for administration of the compact. But are you asking about whether or not there has to be, I guess, maybe I'm not understanding your question. I mean, this would be DCF.
I'll hold my question. I'll hold my question till later.
Okay.
Yeah.
And I think that's really it, kind of in terms of the definitions. We can always go back to some if they come up and we don't have clarity. So section 5903 on page 8, this is applicability. So this is the, where we go back to that says This is where, when the compact applies, and these are the circumstances where the compact doesn't apply. So you'll see in subsection A, compact applies to the interstate placement of kids subject to ongoing court jurisdiction in the sending state due to allegations of that the child has been abused or neglected, provided that the placement of such a child into a residential facility shall only require notice of a residential placement into the receiving state prior to placement. So we just talked about that notice provision up above. So these are the CHINS kids in subdivision A1. Page 9, subdivision 2, the interstate placement of a child adjudicated delinquent or unmanageable based on the laws of the sending state and subject to ongoing court jurisdiction of the sending state if, you'll see starting on line 4, the child is being placed in a residential facility in another member state and is not already covered by another compact, or the child is being placed in another member state and the determination of safety and suitability of the placement and services required is not provided through another compact. And then lastly on that provision is the interstate placement of any child by a public child placing agency or private child placing agency as a preliminary step to a possible adoption. So we're talking about the CHINS kids, kids who have been adjudicated delinquent, and we're talking about the when a child is being, there's an adoption of a child in one state who is going to be adopted in another state. Do you have questions?
No, thank you.
Oh, I thought you were waving.
I was
Sorry.
saying, Senator Hooker has to leave for
Okay.
another meeting, so I was saying bye to her.
Sure. So on page 9, subsection B, these are the circumstances where the compact doesn't apply. So the first one is where like custody proceedings, where the state is not involved. So if you have, parents who are disagreeing over custody, things like that, this doesn't apply. Because the state is not involved other than the court if the parents are in front of the court to adjudicate parental rights and responsibilities. Subdivision B2 is the interstate placement of a child with a non-relative in a receiving state by a parent who has legal authority to make the placement, provided that the purpose of the placement isn't just kind of like a preliminary step to that person in the other state adopting the child. So if a parent wants to place their child with a relative in another state, the compact does not apply. The next one is B3 at the bottom of the page, and that's interstate placement of a child by one relative with lawful authority to make a placement directly with a relative in a receiving state. So similar to subdivision 2. Page 10, subdivision 4, that's the placement of a child into a residential facility by his or her parent. I think I mentioned a moment ago that I believe that this is one of the differences between the existing compact and the new compact.
Can you just explain that briefly, what the difference is? So it's number 5 on page 10, that's
Subdivision 4.
Oh, division 4, sorry. Yep.
Yep.
Can you explain what is different about this?
So my understanding is that under the current compact, if a parent was going to be placing their child in a residential facility in another state, that the existing compact applies in those circumstances. But in the new language, in this new compact, that would not be the case. And maybe Trissy can talk a little more about that.
Okay.
So would you like me to answer that now?
Sure.
So under the current compact, a parent placing their child in a residential program, they need to have prior approval prior to that child being placed in the current compact. The new compact only requires a notification that the child's there, so the child doesn't have to wait to receive interstate approval before they can go. So that's the main difference for the residential
Okay, so
placement.
it's a notification system rather than an approval system.
Correct.
Okay. Thank you.
So subdivision 5 is placement of a child with a non-custodial parent. And then there are provided certain conditions there, provided that the non-custodial parent proves to the satisfaction of a court in the sending state that they have a substantial relationship with the child. And that the court in the sending state makes written findings that placement with the non-custodial parent is in the best interest of the child. Just noting that best interest is the standard that we use when determining custody under Title 15. So that's consistent there. Subdivision 5C is the court in the sending state dismisses its jurisdiction in interstate placements in which the public child placing agency is a party to the proceeding. Subdivision 6 is a child entering the United States from a foreign country for the purpose of adoption or leaving the US to go to a foreign country for the purpose of adoption. 7 are cases in which a US child is living overseas with their family, at least one of whom is in the armed services and is stationed overseas, and then is removed and placed in a state. And then the last one on line 17 is the sending of a child by a public placing agency or a private placing agency for a visit as defined by the rules of the Interstate Commission.
Michelle,
Yep,
number 7,
yep.
is this the case? So could you just explain, is this like a military, somebody's stationed overseas in the military and their child is with them and they have the child removed for some purpose?
That's how I understand it. Yep.
And they go back to the kid comes back to the United States.
Right, and yes, and goes and lives perhaps with a relative or someone else in the States.
Maybe Tristy knows the answer to this. Why would the compact not apply in that case? What happened? Are there rules for that happening? For the placement of that child if the child's being removed and then coming back?
Currently, the current compact is silent on that matter. It doesn't speak to armed forces in those kinds of situations. So this is new language for the compact.
Oh,
It's also because when you think of the compact, it's an agreement between states that these are the rules that we're going to abide by. If the state where or the country where the child is overseas, there's no agreement there, right? So there's nothing, so it's not.
But if they're living on a military base overseas, like a US military base, then they would be subject to the United States laws. So then they come back home. Wouldn't that, I know there's nothing we can do about this. I'm just concerned that there's no process for that. I'm not sure how often it happens, but it must happen sometimes.
This is really, I think this is new, so we need to understand the basis for putting it in here as an exemption. So is it because it's U.S. Armed Forces? Because as Senator Hardy has said, when you're overseas and you're on a U.S. air base or any base, you're on U.S. property. So I'm trying to.
But not a state.
But not in a state.
Yeah, maybe it's because it's between federal and state, not state and state. I'm just wondering if there are similar protections for the kid.
So does the federal government have anything, or does the military have anything regarding child protection and safety?
I do not know the answer to that, but I can find out.
Okay, that would be helpful.
Just for our own peace of mind.
Well, yeah, no, it's important.
Yeah, I just wonder what the process is. If it's not this, what is it?
Okay, subsection C is still addressing, well, but not kids who are overseas, but kids who are in armed services families, is that for purposes of determining applicability for the act, is that the public placing agency or child or private agency can choose the state of the service member's permanent duty station or the service member's declared legal residence. So there's two options there. So if someone is from Vermont, but they are, you know, they have a permanent duty station in Georgia, then either one can be chosen.
Yeah,
That helps.
that makes sense. It's just if they're overseas.
Right, right.
Alone on an airplane.
Right, so D is just saying that nothing in the compact should be construed to prohibit the concurrent application of this compact with the other compacts that we mentioned. Section 5904 is jurisdiction. And so this is we're gonna be looking at basically, you know, which state has responsibility for different things and has jurisdiction over certain issues. So there are, starting out, so at the first clause there in subsection A is like, there are some exceptions, which we'll go through later in this section. So there are some exceptions, but generally the sending state shall retain jurisdiction over a child with respect to all matters of custody and disposition of the child that it would have had if the child had remained in the sending state. And that jurisdiction includes the power to order the child to be returned to the sending state. Page 12, when an issue of child protection or custody is brought before a court in the receiving state, the court is to confer with the court of the sending state to determine the most appropriate forum for adjudication. So if the child, so it has been sent from Vermont to New Hampshire, the child is New Hampshire, and then a new issue around child protection or custody is raised while they are in New Hampshire, then New Hampshire and Vermont are supposed to talk about that particular issue and to determine which is the most appropriate forum. Subsection C is just kind of some logistics in the cases that are before the courts. They can take testimony for hearings in person or by telephone or audio video conference. Obviously, we're talking about, you know, 2 different states there, so a live appearance is not required. Subsection D is the ability of the court in the sending state to have authority to terminate its own jurisdiction in certain circumstances. So on line 13, subdivision 1, in that circumstance, the child is reunified with the parent in the receiving state who is the subject of allegations or findings of abuse or neglect, only with the concurrence of the public child placing agency in the receiving state. 2 is the child is adopted. 3 is the child turns 18. 4, the child achieves legal independence pursuant to laws of the sending state. So they are emancipated according to the laws of the sending state.
Is any of this new to this compact?
I don't believe so.
Okay.
Can I ask a question? So
Yeah.
Michelle, in paragraph 1,
Yep.
child is reunified with the parents.
Mhm.
Is the assumption that they're reunified because things have gotten better? allegations of and findings of abuse or neglect are settled and it's not an issue anymore? Is that the
That would
assumption?
be, right. I mean, I would assume that that is what's baked in there with regard to reunification, and it's with the concurrence of the public child placing agency in the receiving state. So I'm assuming there wouldn't be a reunification and approval by the local child welfare office if things weren't okay for and safe for that child.
Yeah, okay.
Mm-hmm.
Wanted to make sure.
Sure, yeah. Page 13, subdivision 5, a guardianship is created by a court in the receiving state with the concurrence of the sending state. So both have to be in agreement, but it's the receiving state that issues the guardianship order. Subdivision 6 is an Indian tribe has petitioned for and received jurisdiction from the court in the sending state. And 7 is the public child placing agency of the sending state requests termination and has obtained the concurrence of the public child placing agency in the receiving state. So subsection E is that when a sending state terminates jurisdiction, it lets the receiving state know. So if Vermont determines that it has, met something up above in subsection D, then they let New Hampshire know about that. Subsection F is just to clarify that there's nothing in the compact that would prevent the receiving state from addressing issues of truancy or a crime committed by the child or delinquency, things like that, as defined by the laws of that receiving state. So if a child is Vermont child placed in New Hampshire and then the child gets in trouble, they would still be subject to the jurisdiction of the New Hampshire courts to address that delinquency. Subsection G is is to limit the receiving state's ability to take emergency jurisdiction to protect the child. Subsection H has to do with adoption. So the substantive laws of the state in which an adoption will be finalized are to govern all issues relating to the adoption of the child, and the court in which the adoption proceeding is filed shall have subject matter jurisdiction regarding all matters having to do with the adoption, except a few things here at the top of page 14. When the child is a ward of another court that established jurisdiction over the child prior to the placement. 2 is when the child is in the legal custody of a public agency in the sending state. And 3, when a court in the sending state has otherwise appropriately assumed jurisdiction over the child prior to the submission of the request for approval of placement. And then finally, on subsection I, final adoption decree is not to be entered in any jurisdiction until the placement is authorized as an approved placement by the public child placing agency in the receiving state.
So all of this section is currently in the compact as it currently exists.
I believe so, yes.
Okay. Okay.
So, sorry. So 5905 on placement. So prior to sending a child to a receiving state, should I just, is it more helpful? I'm just wondering, I feel like I stumble at saying public child placing agency. Could I just say DCF for short? And
Yes.
is that okay?
Yeah, no, please. And there are some sections here that are, you can go through at a higher level, that's helpful.
Okay, all right, yeah, tell me if I'm just getting too granular here.
You don't need every word at this point.
Sure. So in subsection A, prior to DCF, sending, bringing, or causing a child to be brought into the receiving state, DCF is to provide a written request for assessment to the receiving state. Subsection B is addressing those situations with regard to private agencies. So upon receipt and immediate review of the required content and a request for approval of a placement in both the sending and receiving state public child placing agency. And so the lines 19 and 20, the required content to accompany a request for approval shall include all of the following. And then you can just, I don't know that you need me to read that. So it's page 15.
Or no, as long as that was actually a question, but so all of the conditions are, evaluation criteria are consistent.
Yes.
Yeah, okay. For every state, each state.
Oh.
Okay.
So those are the conditions. So there has to be a home study. There has to be an acknowledgement of legal risk signed by prospective adoptive parents, certification by attorney that relinquents is in compliance with the law, those types of things up above in subsection B. Subsection C is simply stating that the sending state and the receiving state can request additional information if they need it. Page 16 at the top. We don't need to go through that. Let's see, subsection F. Sorry, I'm skipping around. I'm trying to go a little faster so you don't have to hear some of the standard stuff. So subsection F is assessment by the receiving state. So upon request of DCF in Vermont, New Hampshire is to initiate an assessment of the proposed placement to determine its safety and suitability. So we had talked about the definition of assessment earlier. If the proposed placement is placement with a relative, DCF in Vermont can request a determination for a provisional placement. So it's the receiving state that does the assessment. Subsection G is just, again, DCF can request all the information it needs to be able to be making its determinations. Subsection F is that there is a requirement for completion of the assessment within a reasonable time frame that are going to be established by the rules of the Interstate Commission. Subsection I is if it's a placement by a private agency, the sending state is not permitted to impose any additional requirements to complete the home study that aren't required by the receiving state. So Vermont can't say, you know, oh, we don't like New Hampshire's home study. We need them to do additional things. And that would apply unless the adoption is finalized in the sending state. Let's see, I'm going to move on to section 5906 for placement authority. Subsection A is just that a child cannot be placed into a receiving state until approval for such placement is obtained. Subsection B is outlining what happens if the state does not approve the proposed placement. It's basically the child shall not be placed. There is a process that's in here for seeking administrative review of the receiving state's determination, and that's in subsection C. And Trissy, is this one of the things that is new or different? No, it's not. Okay. So subsection C. So if somebody is an interested party, they have standing to seek an administrative review of the receiving state's determination. So subdivision 1.
I apologize, Michelle. You are
Okay.
correct. That is one of the changes about the the review. So that's more if there was a denial that was issued. There is
Right.
a review process for that denial.
Right, okay, all right.
Each part is new. Can you be specific?
So right now, any decision that's made by a compact administrator, depending on the state, some states have appeal processes to, states can appeal the denials that have been issued. But it's up to each state to make that determination as to whether or not they want to have that kind of appeal process. Here in Vermont, there are no appeals for my decisions. My interstate decisions are final. So this creates an administrative review process for all states to have.
Okay, so you would be a part of that review?
So for example, if I issued a denial for a New Hampshire child, the state of New Hampshire could request a review of my decision, and vice versa. So if another state issued a denial that I didn't agree with, I could request a review, an administrative review of that denial to that other state. And then they would have to go through an administrative review process.
Okay, so the review with a denial, it can go in either direction, as the administrator or the state can request that review.
Correct.
All right.
And that makes it consistent, whereas now it depends on the state. Is that right?
That is correct.
Okay.
It creates some due process.
Yeah, great, thank you.
In your experience, has this been an issue? There must be something driving the change, that's all.
I think that because of the inconsistencies on the assessment process of how families are assessed for suitability, that it makes sense to have an administrative review process to be able to appeal decisions. The way that sometimes we assess safety and suitability looks different in other parts of the country. And so having a mechanism to kind of challenge a decision, I think is important and helpful.
Thank you, that's helpful.
So I'm going to move on to page 18, section 5907. And so that is the placing agency responsibility. So for subsection A, interstate placement of a child made by DCF or state court, you'll see line 6, the public agency in the sending state shall have financial responsibility for the ongoing support and maintenance of the child during the period of placement, unless otherwise provided by the receiving state, and as determined by the public agency in the sending state, services for the child beyond the public services for which the child is eligible in the receiving state. You see on line 14, the receiving state only has financial responsibility for any assessment that they conduct and supervision conducted by the receiving state at the level necessary to support the placement as agreed upon by the public agency of the receiving and the sending state. Subdivision 3 is just saying that there's nothing in here that prevents the agencies from contracting for services to be able to do assessments and providing supervision, et cetera. So subsection B, and this is so up above, we were talking about financial responsibility for the public agencies. B is for placement by a private agency that is preliminary to adoption. That agency is to be legally responsible for the child during the period of placement, and financially responsible for the child absent a contractual agreement to the contrary. Subsection C is just that the public agency in the receiving state has to provide timely assessments. I don't think it's okay. I'm just going to skip stuff that I think is just kind of procedural and the same, if that's all right. F, actually, I will just note, each member state shall provide for coordination among the branches concerning the state's participation in and compliance with the compact. through the creation of an advisory council or use of an existing body or board. So that's Trissy.
Is there another board or is it just Trissy? Does she have an advisory council?
Not for this compact. So the Interstate Commission on Juveniles, ICJ, when that one was updated about 11 years ago, it had this same requirement of the creation of a council, and Representative Pugh from the Health Human Services, she represents as the legislative member on my council for ICJ. The current ICPC compact does not have that requirement to have a council.
Okay.
So what is new here then?
That is new to have the requirement of the creation of a council, an advisory council.
Okay. That's page 20. What number is that? Can you just go back up to page 19 very briefly?
Yep, it's subsection F.
Subsection F under.
At the bottom of page 20. So it's section 5907, subsection F.
And every state will have their own advisory council. Each state will have its own advisory council.
Yes.
Okay.
Right. So I guess while we're on that, I was going to skip over it, but G, each member state shall establish a central state compact office that has to be responsible for state compliance. But that's Trissy. So I just assumed that this advisory council, that you had your own advisory council that did the other one, but thank you for clarifying that. Okay, section 5908. On page 20. This is just this is just kind of talking about the establishment of the Interstate Commission. You'll see starting at the bottom of the page on line 19, it just starts to go through and say what the commission is. So it's a joint commission of member states that has the responsibilities and powers that are set forth. I don't know how much you really care about this stuff. It talks about there's one commissioner from each member state who is to be appointed by the head of the State Human Services Administration that has responsibility for child welfare program. And that one person has the ability to vote on policy related matters. So, and this just sets forth the procedures, when basically each member state gets one vote, talks about what constitutes a quorum. You can't do proxy votes, that sort of thing. I'm just going to kind of skip over, I think, a lot of that.
So this is all the boilerplate establishment of the compact that is currently in statute. Is there anything new in any of these sections that we're going to see?
I think it's substantially similar. I don't know if there's any little small nuanced differences, Trissy, or if you have anything.
I think one of the bigger differences comes in 5909.
Right, on powers and duties.
Yes.
Right,
okay.
Right. So let's move on to that. So on page 22. On section 5909, which is on page 22, these are the powers that the commission has. So big one is that they're going to promulgate rules, which is going to really flesh out a lot of the really granular details of the compact. They're going to provide for dispute resolution between the states. They can issue advisory opinions to help guide the states in their compliance and enforcement with the compact. They will be enforcing compliance. They are going to collect standardized data concerning the interstate placement of children subject to the compact. Establish and maintain offices as might be necessary, purchase and maintain insurance bonds. Moving on to page 23, they can hire and contract with consultants. They can establish and appoint committees and officers. They can accept donations and grants of money. They can lease and purchase property, et cetera, et cetera. I think this is all pretty standard. So,
which part, sorry, Michelle, which part of 5909 is new?
Well, the rulemaking, I know with regard, and maybe we're going to talk a little bit more on the rulemaking. The rulemaking process, I know one of the changes is that they are to accept public comment on the with regard to rulemaking. Okay. And then Tracy, I don't know if that's what you were talking about, or if there's another one that you were talking about with regard that was different.
That was one of the differences, as well as the dispute resolution.
Dispute resolution, right.
And then the advisory opinions, that was something that is more explicit that can happen. And the enforcement, it really is gonna flush out the enforcement piece. While there is enforcement in the current compact, this is gonna make it a lot more clear.
Okay.
I will note here that on 15 is they do have a duty to report annually to the member states concerning their activities, and also any recommendations that have been adopted by the commission. So they would be communicating with you about any updates to the compact.
Michelle?
Yep.
So what if it looks like the dispute resolution is between two states? So if Vermont and New Hampshire had a dispute, the compact would help resolve that dispute, right?
Yes.
What if somebody has a dispute with the commission, a state? Say, what if Trissy doesn't like something the commission is doing? Is there a dispute resolution for that?
I don't believe so.
Or any kind of appeal process?
Well, the denial that we looked at earlier, but
that's a different thing. We're talking here.
That's extensive.
So wait, so explain. So can you explain a little more about what your question is? I'm sorry.
Well, one of the things that this new compact does is establish an appeals process between states that doesn't currently exist, like we talked about in the previous section. Is there an appeals process or some kind of dispute resolution process between a state and the commission itself, the overarching entity?
Not that I know of. I mean, the other situation with regard to the appeals process has to do with when there is a determination of like a placement isn't appropriate.
Right.
And so that's kind of more talking about a particular case and things like that. You know, Vermont would, if they adopt the compact, would have a seat at the table in developing the rules. So it may be that Vermont isn't in the majority in agreeing that a rule should say a certain thing, but that's just, you know, it just works just like your committee, which is that, you know, sometimes things get adopted, but not unanimously, and that's how it goes.
Right, no, that's not what I mean. It's more, I mean, the commission, the Interstate Commission of Commissioners from each state oversees to make sure that the compact is working the way it should work, or the way that's following the laws and the rules that are established. What if there's a dispute between the commission and the state? It's
An individual state.
an individual state saying that they don't like the way the commission is overseeing. I'm just trying to figure out what sort of authority and powers do we give up completely by going with this compact, and where's an avenue if is it just through the single commissioner that we have on the board?
Right. It looks like Trissy can
Can I-
answer that.
Well, I don't know if I can answer it, but I guess I can speak to kind of a process that already exists that would continue to exist with the with the adoption of this new compact, is that the commission has an executive body that is comprised of compact administrators. So I just finished my term. I previously served on the executive committee for right before the pandemic up until this past fall. And so it's not the commission kind of on its own independently making decisions. The commission serves at what the executive committee is directing them to do. And generally speaking, the executive committee is making decisions based on what the member body is asking for. So there is, and when there are disputes, because I think similarly to what happens in the legislature, not everybody is in agreement as to how processes happen. There are then states have the ability to, with the new compact, make requests to change rules or to change people get voted in to represent the commission on the executive committee. And so those are ways that you can effectuate some of those changes.
Okay, that's helpful.
Does that help?
Yes, thank you.
So the commission is not going to do something outside of what the executive body committee is directing them to do.
Okay. And are the seats on the executive, that sounds like they're rotating between member states, between?
It's voted, so people
Oh.
can either be volunteer to run for office for one of the seats. So there's currently there's the president, the vice president, the secretary and treasurer, and then I believe there's 3 members at large, and then 2 backups after that. And then those positions do rotate. I don't remember how long each term is. And people are voted in every time there's a new term.
Got it. Okay, thank you.
So I'm on page 24. So 5910 is just organization and operation of the commission. So just wanted to kind of highlight that that within 12 months after the first meeting, they have to adopt bylaws to govern their conduct. Page 25, meetings, they're to meet at least once each calendar year. Public notice is to be given for all of the meetings. Again, I think this is just kind of standard, so I'm just going to skip over it. Let me know if you have any questions. Page 26, there's a provision on line 5, starting on line 5, that they are permitted to close a meeting if they find it necessary. And if they do that, they're just to reference the relevant exemption provision for closing the meeting. Subdivision 4, just like what we talked about with the states being able to conduct things remotely, the commission can do that as well. Subsection C on line 18 is just some information on the officers and staff for the commission and how they elect among the members, the chairperson, vice chair of the executive committee that Trissy spoke of. page 27, subsection D is qualified immunity and indemnification. So this is generally that, providing immunity from liability for the commission, for certain decisions that get made at the state level, so that they are not held responsible for those. However, you'll see that that's within the scope of, of the duties of the employment, and you'll see it's on lines 14, starting on 14, provided such person shall not be protected from suit or liability for damage, loss, or injury caused by a criminal act or intentional or willful and wanton misconduct. So there are exceptions to that. Again, I think this is a lot of just procedural stuff about the way that the commission operates. So, and I realize we still have quite a bit to get through. So I'm just going to kind of skip over this and go on to rulemaking, if that's okay. So page 29, section 5911 for rulemaking. So the rules are, this is a big part of this compact. So, if you look at the first kind of half of the bill that talks and creates the framework for the compact, but there's a lot that has to be done at the rulemaking stage by the commissioners. And so section 5911 sets forth the how they go about that. The rules are to substantially, or the rulemaking process substantially conform to the principles of Model State Administrative Procedures Act. All of the rules and amendments to rules, just like here, become binding as of the date specified and publishing of the final version of the act, so they would have the force of law. Subsection C at the bottom, the commission shall at a minimum do all the following when they are adopting rules. They're to publish the proposed rules entire text. Subdivision 2 is a new part, which is the allow and invite any and all persons to submit written data, facts, opinions, and arguments, which information shall be added to the record and be made publicly available. So that's allowing for public comment.
Is that new?
Yes.
And that is number?
That is subdivision C2 at the top of page 30.
Yeah. Okay, thank you.
So subsection E is providing for a process for being able to challenge a rule once it's promulgated. So not later than 60 days after final adoption, an interested person can file in district court in DC or in federal district court where the commission's main office is located for judicial review of the rule. If the court finds that the commission's action is not supported by substantial evidence in the rulemaking record, the court shall hold the rule unlawful and set it aside.
So let's clarify here, the rules that are being promulgated relate to which aspects of the commission activities, and how deep does it go? Is it down to the individual child, or is it about various policies or negotiations between amongst states? And
no, just be with regard to the rulemaking. So just like, if you pass a statute and you grant authority to DCF to adopt rules to do, A, B, and C, but you want DCF to flesh out the rules more and the procedures, and then it goes through the process.
okay.
There, and so this would allow someone to, in thinking about like if it was an agency doing it, challenge that agency rule within 60 days, saying that it's not supported by the evidence, and then the court could set it aside. So this is not having to do with individual cases or children or things like that. This is having to do with the rules adopted by the commission.
Okay. Thank you.
Sure. Subsection F is if a majority of the legislatures of the member states rejects a rule, those states may, by enactment of a statute or resolution in the same manner used to adopt the compact, so through legislation, cause that rule to have no force and effect in the member state.
So let me ask a question here, that since we're putting together the advisory committee or council, is there anything here that has that council reviewing the rules, or is it simply left to the representative to the compact? How does that all sugar off?
Well, what's provided here is that it would have to be, it wouldn't be that that advisory council or anybody, you know, independently could say this rule isn't going to apply. It would have to be an action by you, by the General Assembly, to reject that rule.
Right, but there, how do the rules get reviewed? It seems to me the rules are being developed by the compact. Members of the compact are seeing the rules. Public comment is being requested. Is that a broad net to within states to interested parties? Just sorting out how that all
Right. I don't know how they publicize that. I mean, I think,
Okay.
you know, certainly if the, you know, if the standing, if your committee and maybe Human Services wanted to be involved in some way in looking at the proposed rules, you know, you would, be talking to Trissy about, can you let us know when these rules are first being published? We'd like to take a look at them. We'd like to have some input. We'd like to understand what's being discussed. We'd like to have a dialogue about that. But, you're going to have one vote with regard to the rulemaking.
Right.
And then it would just be up to, folks here who are interested to be communicating with that contact to make sure that Vermont's interests are represented in the development of the rules.
Right, well, so it would seem that the advisory council might want to play a role in that, but yeah, okay.
But there's no
There's
formal
nothing.
process to have the rules come to the legislature, like the equivalent of the LCAR process.
No, because if you imagine that, it would be like, so you adopt the compact and then you have rules, and then if they have to go to every state legislature that is part of the compact, I guess it could just be the same.
This isn't a good conversation. I think now that a new council is being formulated, they may well want to look through what they can or should or want to take up going forward. So I don't think we need to do anything here that tells our council that, but.
Well, it just, because it mentions state legislatures
Yes.
rejecting the rules, that the question is how do we know about the rules to reject them or not reject them? So is there a process for notifying the legislature?
I think you're going to have to just rely on your state representative, the people, Trissy or whoever it is that's going to be the representative to the commission.
Contacting the advisory committee.
Yeah. Okay. Why don't we keep going? Because I know that we only have Jen Carby for a half an hour at 10:30.
Right. I think I can do it. I got 10 pages and I'm just going to hit the highlights here.
Getting riveting.
So top of page 31, subsection G is just that the existing rules governing the compact are then going to be superseded by the new rules. No less than 12, but no more than 24 months after the first meeting of the commission. And then they're required by subsection H that within the first 12 months, they have to promulgate the rules. And you'll see here, subsection H just goes through and lists all the different things that, you know, they have to be adopting rules on.
So let's be clear, but this is not totally new.
No,
Yeah.
there's rules existing for the compact now. And so, you know, you're replacing the compact, and so they have to adopt new rules. My guess is that probably a lot of the rules will be quite similar to the ones they have now. And just kind of refining them, improving the ones that are kind of generically the same. And then when there's been a policy change, you know, at the compact level, then, you know, they'll be creating new ones for that.
So, but this is asking them to promulgate rules, but they've already got rules. So so it doesn't read update rules. There's nothing there, just simply continue to go forward the way they have.
No, so within a certain period of time, the old rules are going to disappear. Just like like with this act, you would be repealing the existing statutory compact that we have in Title 33 and replacing it with this. That's what they would be doing here under the new one.
Thank you.
Yep.
So either keep these rules or replace them with new ones?
Yes.
And then you can just look at the list there, but it's a nice long list of all the things they have to consider, and it's not exhaustive. They can also, they have the authority to do emergency rules. That's top of page 32. And you'll see the criteria there for being able to adopt emergency rules. Those emergency rules become effective immediately upon adoption. Section 5912 is oversight, dispute resolution, and enforcement. So the commission oversees the administration and the operation of the compact. The executive, legislative, and judicial branches of state government in each member state shall enforce the compact and the rules of the commission and take action necessary and appropriate to effectuate the compact's purpose. Subsection B is dispute resolution. Any member state can request of the commission to resolve disputes about the compact that arise among the states and between member states, and also between with a member state and a non-member state. So the commission, one of the things that they're supposed to do rulemaking on is around mediation and binding dispute resolution. Page 34, subsection C is on enforcement. If the commission makes a determination that a member state has defaulted in performance of its obligations under the compact, they can do a few things. Starting at line 7 on page 34, they can provide remedial training and provide specific technical assistance. They can provide written notice to the defaulting state of the nature of the default and how they can cure that default. And then subdivision 3 is by a majority vote of the members, they can initiate against the state legal action in federal court to enforce compliance with provisions of the compact.
And this is not new.
No, is this new? Oh, this is new.
That is new.
Okay.
Page 35, section 5913. This is just on how the commission operates and financing of the commission. They can collect an annual assessment from each member state to cover the cost of operation and activities of the commission. I don't know whether or not Tracy talked at all about that under the existing one or not. I don't know what that entails. Subsection C, commission is not to incur any obligations. Oh, that doesn't matter. Let's see. Member states effective date and amendment. So I think I'm sure you've talked about it already. So you have to, in order for it to take effect, you have to have at least 35 states adopt the compact. And then it becomes law after the 35th state has adopted. 5915 at the bottom of the page is how you can withdraw. So page 37, you look at subdivision 2, withdrawal from the compact shall be by the enactment of statute. So just like you're adopting the compact, you would repeal it through legislation. If the state is withdrawing, they have to immediately notify the commission upon in writing that they are going to be withdrawing. Subsection B provides for process for dissolution of the compact. 5916 is severability. We have a general severability clause in our statutes that applies throughout, but a lot of kind of standard compacts and things like that will have their own severability clause. That just means generally that if there is one part of the compact that is struck down, that the remaining provisions of the compact would still be enforceable. I'm going to skip over some of that. Subchapter 2. Trissy just sent me a notice in the chat. No, at the beginning, don't worry about it.
Don't worry about it. Ignore that.
So subchapter 2, this is on, so if you look at 5921, financial responsibility is to be determined. We had an earlier section on that. Let's see, section 5922. I'm trying to remember. Trissy, can you remind me what I was trying to remember, because we had to re-adopt this, right?
Yes,
I'm trying to remember in Human Services why we added this in.
5924, you mean?
No, just the subchapter 2.
We currently have a subchapter 2.
Right.
So it creates due process rights for children in DCF custody when we wish to place them in an out-of-state residential facility. So it's just continuing those due process rights, giving those children due process rights within this compact.
Right, but did we change anything? I'm sorry, I forgot about this piece on there.
There's been a lot of iterations of this, Michelle.
Right,
changes,
that's what
so
I was trying to remember, that it was a few years, it was.
So one of the things that changed was the language as to which children. I believe in the current statute, it just speaks to neglected or unmanageable children. It doesn't speak to the CHINS A children of abused. So this changed the language to all children, because this new compact, so in the current compact, youth who are adjudicated delinquents are required to have a court hearing in order to send them to an out-of-state residential facility. This new compact does not have that same process in it. So we changed the language to be broader, to just say all children in the custody of DCF have the right to a hearing.
Right.
And
okay.
It would be, I think, helpful. This sounds like a really important section that's being modified. Can you send us actually, what would be very helpful would be to get a summary of the changes that are here, what's new, with a sentence or two about the justification for those changes.
Sure.
Okay.
Sure. Oh yeah, I'll circle back to that. Sorry about that. I forgot that this, because I think the bill as originally introduced, we didn't have this piece, and I just put in a request for the old file, which we sent to Middlesex, the when it had passed the House, and all my notes are in that one. And then I just wanted to wrap up with, so on page 41 on the effective dates. So it's a little tricky in the sense that if you think about, you can't just say, you know, we're gonna adopt this and it takes effect, because it doesn't actually take effect until you have the 35th state come on board. And so we were trying to think about the timing of it. So the way that the effective date would work is that, so sections 1 and 2, so the bulk of the compact, would take effect 18 months from the date on which the compact is enacted into law by 35 states. And the idea for that is that the hope is that 18 months after that 35th state has adopted it, that they would have done the rules by then. Is that, and so that, because I think there was a concern of just about truing everything up and being able to make sure that you didn't have kind of some weirdness where, you know, because you're repealing the old law and then you're putting the new one in, but yet it doesn't actually take effect. So we were just trying to figure out some creative way to do that. So that's what we came up with.
Okay.
And my recollection, Tracy, was that you ran this by folks, right?
Yes.
Yes, and that you, so yeah, I think we spent a lot of time trying to figure this one out when it was in the House a few years ago. And so I think, yeah, so we got an okay that this language worked for them.
I need to ask one question, and then we're probably going to have to come back to this early tomorrow or Thursday. We have about a half an hour each of those days to look at this bill and maybe get to some closure on it. But the question is the appointment of the administrator with terms of 5907 of this title. And when I go back and look, you don't have to clarify this now, but please go back and look at 5907 and confirm that that's the section that should be related here. That section looks like it's about kids rather than an appointment. So anyway, yeah, but we can hear the results of that, I think. Aaron, do we have time tomorrow morning at 8:30 or?
If you want, yes.
Yes, we have time tomorrow morning at 8:30 to go to look at the summary of new sections and maybe clarify that 5907 is the right section. And then we'll have finished, I think, what we need to hear about the compact. How many states are now members?
13. 13 are members. The state of New Hampshire is taking it up this session as well.
Okay, all right, that's helpful.
We gotta beat New Hampshire so we can be 14th.
We're in, that's right. That's our number.
That's our number, our lucky number. So we would take this up tomorrow and
8:30.
potentially vote it out.
Well,
unless
we'll
there are
think about it.
issues. Yeah.
Okay, so we'll do that. Michelle, thank you so much. And Trissy, thank you so much for being here and helping us through this. It's actually very interesting. So
It is really
yeah,
interesting.
great.
It also makes me a little sad.
It's very sad. It is sad. Okay, so is 8:30 tomorrow morning a possibility then to go through this, just the new parts and the clarifications that we might have? Terrific. That's awesome. But we'll see you both then, and we're going to move on right now to another bill so we can complete our work for the day. So thank you so much. Okay. So is Jen?
She's coming to the room.
She's coming in
Here.
the room here?
Yeah.
Oh my God.
Yeah.
Wow. Yeah, take a little stand up.
It's weird to
Ruth, just open the door and see if she's there.
This is an odd chair to be sitting in because the camera is pointing that way, and when I look this way, it looks like I'm not paying attention.
I know.
Sorry, we're ready. She was chatting with Jen.
Of course she was.
Jen Carvey, welcome.
Hi, Erin, nice to meet you.
I know, it's just, it's like interesting. All right, well, you know, this is great. We know that you've been working hard, and that Senator Hardy's been working hard on freestanding birthing centers. I just want to say up front that each of us has been working on individual bills. We each took some leadership on those bills, and so we're going to go through those as best we can. So, Jen Carvey for the record, and
Yes,
we go through 204.
Jen Kirby, Office of Legislative Counsel. We are looking at S204. This is a strike all amendment, but the first full section on licensing of birth centers is actually unchanged from the bill as introduced. So we can go through it if you'd like, but there are no
Oh,
changes.
wait, do we have it posted?
Yeah.
Okay, I just had to refresh.
Do you want me to go through the language? I could just do maybe a high level overview.
Hang on a second, I'm just, be patient with me, my iPad isn't being helpful.
We're in person, but still.
Got it.
I know, it's both
Okay.
familiar and very strange.
There we go.
Yeah, exactly.
Thank you, Jen.
Sure, okay, so I'll just do a high level overview of section 1 because as I said, it has not changed. This would add a chapter in Title 18 on birth center licensing. So it starts out with a definition, and it's a birth center is a facility that's not a hospital or part of a hospital where births are planned to occur away from a person's home following a low-risk pregnancy, and that provide prenatal, labor and delivery, or postpartum care, or a combination, and other services in accordance with the relevant scopes of practice of the healthcare professionals who work there. So it prohibits anyone from having a birth center, establishing, maintaining, or operating one without getting a license. It has an application fee of $300. This would go to the health department. It's the health department that would do the licensing. It does provide for renewal of an existing license can be done through deeming based on current accreditation by the Commission for the Accreditation of Birth Centers or a similar accrediting entity, and then they would still pay the fee because it still requires oversight and regulation by the department. So licensure requirements, there are certain criteria that the health department would have to make sure that the applicant meets, like demonstrating the capacity to operate a birth center in accordance with department rules, demonstrating that the facilities comply with standards for health, safety, and sanitation based on state law and municipal ordinance, a process for responding to patient complaints, agree to participate in the patient safety surveillance and improvement section in state law, and allowing the department to inspect the facility and the grounds at any time. Then it has a process that again is lined up with what is in our hospital and ambulatory surgical center laws now on revocation of a license, appeal, inspections, and confidentiality of records. Directs the department to adopt rules, that's on page 5. And those go into some detail about regulating birth centers in accordance with national birth centers, may include what services can be provided at the birth center, what the appropriate staffing is, and a requirement for written practice guidelines and procedures, including procedures for transferring a patient to a hospital if necessary. Section 2 is also unchanged. That is midwifery coverage under health insurance and specifying that insurance would need to cover maternity benefits provided at, or prenatal, maternity, postpartum, and newborn services provided at a birth center. Then we get on page 7 into what has changed. So section 3 of the bill as introduced gave an exclusion from the certificate of need laws for birth centers. This would take out that section. Instead, it would put in new sections 3 and 4. Section 3 would just add a definition in the CON chapter for freestanding birth center, and it would have the same meaning as birth center in the licensing chapter. And then for CON, it would add to the existing list of healthcare facilities that must get a certificate of need prior to developing or having developed on their behalf a new healthcare project, and defines a new healthcare project to include the construction, development, purchase, lease, or other establishment of a freestanding birth center. Just added this on to the existing provision for ambulatory surgical centers added a few years ago. The timing of this will play in when we get to the end. So Section 5 directs the Green Mountain Care Board in connection with its responsibility for developing and maintaining the state's health resource allocation plan, the HRAP. In connection with that responsibility, the Green Mountain Care Board, in consultation with the Health Department's Maternal and Child Health Division and the Blueprint for Health's Women's Health Initiative, to conduct an assessment of the need in this state for the obstetric and midwifery services offered by freestanding birth centers. And that assessment would include evaluating the need for the services in particular regions of the state and for certain populations of Vermont residents. And then by April 1st of 2023, and this is based on an estimate from the board and it's the partners that would be directed to work with on how long this needs assessment would take. So April 1st, 2023, the board would provide to this committee and to the House Committee on Healthcare its findings and recommendations regarding the need for the services of freestanding birth centers in Vermont, along with a recommendation for whether persons seeking to establish a birth center should be required to obtain a certificate of need. So they do the needs assessment to see if these birth centers are necessary to meet a need they've identified in the state, and if so, should they be required to get a CON. Section 6 is the same as the bill as introduced, just renumbered, directing AHS to seek approval from the Centers for Medicare and Medicaid Services to let Vermont Medicaid cover prenatal, maternity, postpartum, and newborn services provided at a licensed birth center, and to allow Vermont Medicaid to reimburse separately for birth center services and professional services. And then the effective date section, so the chapter on licensure and the section on health insurance coverage would take effect on January 1st, 2024. So you get the report in April of 2023, and the licensure doesn't take effect until, it doesn't start until 2024. Sections 3 and 4 on the certificate of need would take effect on July 1st, 2023. So if the report comes back in April and says, yes, there's a need and CON is appropriate, then that provision, that requirement would take effect July 1st, 2023. Section 5, which is that needs assessment and the effective dates there would take effect on passage. And Section 6, which is directing AHS to request Medicaid coverage approval from CMS, would take effect on January 1st, 2023. And there's some additional language about when when AHS has to submit its request for approval so that the coverage could begin on the later of the date of approval or January 1st, 2024. DVA has, I don't know if DVA's here, but DVA has sent a communication this morning saying they don't think the rest of the language is necessary. That they just think January 1st, 2023 would work for them. Although I'm not sure we need to do 2023 if the licensure can't start until 2024. So you may want to just set 2024.
Okay, nice the end. So we're saying, yes, we're going to allow birthing centers. They have to go through a certificate of need. But first, we're going to see if the Green Mountain Care Board agrees that they should be allowed and whether or not they need a certificate of need.
Right, it's effectively setting a process in motion to start at a later date.
So that once it's okay, it can just proceed.
Exactly.
Okay.
I've seen this once, but there's nothing that talks about the system. I'm very concerned.
You okay?
Yeah, something's tingling my throat. Let me go out and I'll be back. I'd like to talk about the system of, the whole system. I'm concerned that hospitals are shutting down their obstetrics, the delivery services. And so you put up a birthing center and you're 50 miles from a hospital that can serve you in an emergency. And I'd like to have it, not just look at the centers, but at the system as a whole.
Yeah, I think probably Senator Hardy and I are gonna say the same thing or similar about the
Yeah, so,
plan. Go ahead.
are you okay? Do you want to wait till?
No, I have something is tickling my.
I got it. Well, if you need to leave, I can,
Okay.
but so in talking to, I had a meeting with the Green Mountain Care Board about this, to try to figure out, the conversation we had about where would we place birthing centers, or if ideally we could say they're needed here, here, here. So that's basically what they do with the HRAF planning process, is they look at the big picture of the need for particular types of services in the state. So they suggested tying it to the HRAF, and that's why it says in conjunction with or whatever. And then they also suggested bringing the VDH and the blueprint subject area experts in. So there would be a sort of state level needs assessment of where the services might be necessary, what regions or for what populations. Because I think we heard there are certain populations that may be a benefit from birthing centers in certain regions. The other thing in my conversations with them is that the birth rate in Vermont is so low that they are skeptical that there are any regions of the state where a freestanding birth center would be financially viable. And that it's possible that the only part of the state that a place would be financially viable is Chittenden County. So it doesn't actually, it wouldn't meet the need that you're talking about of like in the middle of nowhere having a birth center that would be more easily accessible, because there would be 1 or 2 births there a year and it wouldn't make it financially viable. So they would be looking at that sort of whole process in their assessment.
As long as we're doing a big.
Yeah, I had the same concerns, and trying and also having it conflict with and potentially shut down other facilities that are necessary. So they also said it would take, I think what they say, 9 months. So that's why it's built in, that deadline is built in, to make sure that they had enough time to do that kind of thing. And they have data on births and where they are, what kind of births they are, et cetera, so they can really look. They also said that if it's determined that there is a need, their process will basically do most of the CON process for the freestanding birthing centers, because a lot of what the CON process is establishing that there's a need. Their research would have basically established whether or not there's a need. And even if they recommend a CON, they will have done basically a bunch of the work that would have gone into a CON, making a CON easier if they indeed say it's necessary. They might come back and say, there is a huge need, we should do these and we don't need a needs assessment, or there's a need just in this one place. If this one place has a birthing center, we don't need a CON, but other places would, something like that.
Right, it could validate what we've been hearing about the distance from where people want to have their children to a hospital, or however that happens. And the HRAF, it's great to invoke the HRAF. It's been years that it's been in place, and it's nice to see that it's getting to be at work, so it's great.
And they said that they had a list of sort of subject areas that they wanted to do for the HRAF process. And by us, if this passes, it would just move this off their list.
So this is good, thank you. Does that answer your question? I think
Yes, it does.
based on the work that Senator Hardy's been doing with Jen and others, so it's good. So I did have an email from Nissa James at Medicaid asking that the date for that Medicaid be put out to 2023, and it looks like we've accomplished that goal. I responded to her. She was looking at the older bill, I think, so I've asked her to review the current draft. So we may hear again from Medicaid folks.
Okay, yeah, I think it may make sense to move the date out to January 1st, 2024, just to be consistent with the health insurance coverage and when the services would begin being available. But it would be great to hear from Nissa and Diva about what.
Right, I'll make sure that she connects with you.
Great,
as
yes,
well.
and yes, and I have been on the emails as well.
Okay. All right, any other questions for Jen on this? So the new sections sort of help a great deal in terms of the CON and the review of need overall. Any other questions here?
I'd like.
What would you like,
Senator Hardy, if you had a data, you were talking about the data. The number of women who have delivered outside of hospitals, I mean, it would be a good thing to know. I know that we heard that there are a number of women from the Rutland area who would prefer to use midwives and have to travel distances.
Yeah, this is a good question. Probably having, we can get that data, I think, from Maternal and Child Health Division at DOH.
I'm sure we can get data, and that would be part of what the process would be.
Right.
Process
Is that,
it'd be interesting to know when we're talking to our constituents. I know I was talking to the president of regional medical, and he has the concerns about not taking away from the birthing centers at the hospitals.
Right.
And yet I'm wondering, what are the numbers of women who are doing this, and how has it been affecting the hospital? I mean, we have low birth rates there as well.
yeah,
And I know there's a real concern about keeping those departments open, especially for emergency situations.
Right.
So you don't want to be far away from the hospital, and yet you want to be able to accommodate families that would prefer not to have that hospital.
Well, the
setting.
hospitals have to have that staff on 24/7.
Exactly.
And that was the cost. You can't just call somebody in at 2 in the morning when there's an emergency.
But
It's
there-
not general surgery.
Right, but there are some hospitals that have midwives associated with them and some that don't. And
Right.
and Rutland is one that doesn't, and I know that they're going to be talking about that.
Well, and it may
possibility.
change as a result of this. We don't know.
yeah, they might hurry up and get there. I talked to my hospital over the break, and they said that they actually benefit from the fact that Rutland doesn't have midwives, because a lot of people come up to
Exactly,
Porter
to
to have their
Porter,
babies.
to
'cause
Porter
we have
to
a-
give her.
They have a really neat,
Yeah, they have a new birthing center that has a lot of midwives,
Yeah.
which wasn't there when I had my babies. I had mine at home because I wanted to have with a midwife. So I'm wondering also in this needs assessment, it'll be interesting to see how many women are having their babies at home versus in the hospital, and is that already meeting the need of wanting two different experiences, or is there a need for this sort of third option?
And many, many years ago, I remember the hospital attempting to make the birthing centers more home-like. But I also remember our fourth delivery was an emergency, and, I was glad that we were close by, that we were there, so that it would be taken care of. So these things are.
yeah, they're very important.
It
They're
seemed like this
critical.
was a good interim step to try to get more information.
So I guess the question on this one is, if you're feeling comfortable with this draft, it is up on our webpage. It's been up there today. So I think let's let it, what do you call that?
Percolate.
And then we'll come back to it. And I think unless we hear strong opposition, I think we're ready to.
Well, I'm sure that a lot of the midwives who would like to immediately start a freestanding birthing center will not be happy with it. So just, I've already heard from several of them this morning.
Of course, well, I think we've taken this will take a large step forward, and it sets some goals for Medicaid as well as the CON process. It won't be as onerous, it would seem, as long as with the needs assessment going on. All right. Anything else on this, Jen?
No.
And I'll make sure that Nissa reaches out.
Yep, I've already emailed her.
Good, because I just sent her a note, and I suggested that she
Right.
look at the
I
new
responded
draft.
to yours and asked.
Okay, and the language that she sent, I think, she may be happier with what's here. Okay, all right, we're good. I think. Oh, thank you so much, and I know we're gonna see you again, so. That's great. Do they have those at the
Well, I don't think so.